feel let down? Because at least when it came down to civil union, it was the rights that you were looking at, maybe not the sanctity of it, or at least right now not the sanctity of it. Zainab, that's questions for you. Harish, can you take that question? I don't think Zainab can hear me.
I think what we were looking for is a passage to the right towards civil unions. I mean, in the sense, what is marriage? If you remove if you look at the Hindu Marriage Act, the Muslim Marriage Act, you look at all the marriage acts, it's basically a legal contract between two people. Even if there was a pathway to a legal contract, where there's some sort of legal recognition to a relationship, call it civil union, call it whatever good word that we could choose for it. But if there was some sort of a legal contract, pathway to a legal contract between two people that they could get into, it would have been beautiful. Because what really are we fighting for? We are really fighting for not just the right to sing "Hum Aapke Hain Kaun," have "Hum Aapke Hain Kaun" kind of weddings. That's not the right that we are fighting for. We are already having "Hum Aapke Hain Kaun" type weddings. LGBT people are having those weddings. We are asking for legal recognition of those relationships. So if there was a pathway, some sort of a pathway towards the legal recognition. And seriously, the other thing that I also wanted to stress on is the Supreme Court has done exactly what the Navteej Singh Johar judgment, the directive to the government was that you need to create more awareness, you need to ensure that there's less prejudice. Those were the same directives that were given to the government. There's the same history repeating itself. You're just giving directives over directives, but not having any. There is no timeline to it. There is no plan to it.
Right. Harish, stay with me. I want to bring in Hitesh Jain into this conversation, Advocate Supreme Court. Hitesh Jain, you said you call this the verdict historic. Why so? Because especially where the petitioners are concerned, they're deeply disappointed because we were standing at the cusp of history and we just didn't take that leap.
Well, I don't think you have to look at this judgment only from the lens as to who has got what and who is not getting anything. First thing, as far as the doctrine of separation of powers is concerned, I think we have made a progress where the Supreme Court has said that in a strict sense, we do not follow the doctrine of separation of powers, but we recognize the essential functions of one arm of the state. And as far as the essential functions doctrine, which was introduced today by the Supreme Court has clearly stated that one arm of the state will not encroach upon the essential function of another arm. Second, this judgment also, we have seen, one can see and a progress has been made. This case was not about for or against case for the LGBT. As far as the government of the day is concerned, the government clearly recognized the rights and acknowledged the rights that flowed, as the earlier speaker was mentioning, that was given by the Supreme Court in the Navteej Singh. The government has acknowledged the right. The only question that was pending before the court, and which is the most important question, whether the Supreme Court can grant such rights or such rights have to be granted by the legislature. As far as the right to queer is concerned, it is a very important recognition the Supreme Court has given, and unanimously all the 5 judges have recognized the rights of queer, the rights that they are entitled, basic domestic rights, basic fundamental rights have been acknowledged and have been respected. The only thing what the Supreme Court has done today is they are saying that as far as all the other rights are concerned, it does not come within our domain. You have to go to the parliament. The parliament is the right and the appropriate forum. And therefore, it is the parliament which is the important stakeholder. The Supreme Court has also taken on record about the suggestion that was made by the government of the day when the Solicitor General made a statement that a committee headed by a cabinet secretary will be appointed, which will look into all the issues and then take a proper informed decision. So I think we have made a progress. It's and therefore I say this is a historic verdict.
But, the petitioners don't see it as historic. But let me bring in Karuna Nandi into this conversation. Karuna Nandi, where did we fall short, where the Supreme Court ruling today was concerned? The petitioners were hoping history would be made. But having said that, If the top court hadn't touched the issue of marriage, could they have done more on civil union?
What we were hoping, and we were hoping for at the very least, was a declaration that there is a constitutional right for queer people to be married, and for then that to be taken forward in future decisions or in future legislations. Now, two judges have made that finding. They have not said that there is a fundamental right to marry, but they have said that there are particular aspects of marriage that find themselves rooted in Article 21, in Article 19, and for example, the Article 14 analysis of the CARA guidelines with regard to the ability and the right of queer parents to adopt as a couple is rooted in Article 14, and there is a very robust analysis of that. So, and I encourage law students and lawyers to look at that, and indeed I encourage the government to look at that, because the object of when two of the most senior judges of the Supreme Court say that there is nothing to show that queer parents are not as loving and that as heterosexual parents, that they provide as safe an environment, that these children have a right to respect and dignity and the same rights that other children have, then I think that at the very least, the government should sit up and listen. Now, what the court has done today, and these are small gains. And I just want to also be clear that we have not gone backwards. We have gone forwards, though the steps are far smaller than our petitioners hoped for. However, queerness has been recognized. There was a lot of talk of same-sex marriage in which non-binary and trans people were being ignored. So queerness and the concomitant rights that come with being a human being of any sexuality, there is a sort of broad, abstract recognition, I think, across the board of those rights. The disagreement comes where two judges have said that the right to marry is rooted in some constitutional rights, and the other three do not agree. But all seem to agree that this is a matter of statute for various legislatures, something, of course, that the petitioners disagree with. In particular, for example, our written submissions, and we briefly touched upon these arguments, as well as Saurabh Kirpal, that Section 15 to 18 provides an entire code where sex is not even mentioned, and nothing needed to be read down, nothing needed to be read in, and just a declaration would have sufficed. However, the right of trans people, when they are of opposite chosen genders, to marry has been recognized. The right and modalities of protecting queer couples against false, illegal action by non-state actors, as well as against criminal cases, that has been recognized. There is encouragement by Justice Kaul to look at an anti-discrimination law, and that is really the need of the hour. It's extremely important.
Right. But Ms. Nandi, I'll ask you one quick question before, because we have to close the show soon. So I want to ask you, what's the way forward legally now? So, how do you proceed as a lawyer of the petitioners, and how do they proceed if they want to keep the good fight going?
Well, at the moment, really, the ball is in the court of the legislatures. And let us remember that this includes the state legislatures. The state legislatures and the Congress, the other parties that are in and out of power, the DMK, the BJD, all have, under the Constitution, powers over health, for example. So, for example, a government order or a notification can be issued to say that you must, when a queer person appoints their partner to make decisions over their health when they are incapacitated and they can't make these decisions, then the natal family that rejected them in the first place and that they haven't seen for years cannot be the people that make these decisions for them.
Right.
There are many things that can be done, and there are many things that can be done today.
Right. You know,
Since the union government is speaking in a sympathetic voice, the union government can do the same. It is incumbent, I think, on all the legislatures.
But the union government, Ms. Nandi, had been of the view that homosexuality is an urban concept in any case. You know, having said that, I want to go back to the two petitioners, Harish Iyer, Zainab Patel. Zainab Patel, with what Ms. Nandi was also stating, do you have faith in the legislature to actually, you know, go ahead and follow, at least in spirit, what the Supreme Court asked of it?
I think as a commoner, I will have to put some trust into the legislature before, because this is a step now in their court. I will work with them like the way we did when the expert committee on transgender issues was set up in the early 2012, 2013. We are willing to work with the government to make sure that at least some of the rights within the framework of a union, a civil union or partnership is made available to desirous couples. The rest in terms of the next legal roadmap will have actually be determined once we speak to a larger cohort of lawyers, etc., in terms of what is it that we could do in the next step. And of course, as Karuna rightly mentioned, we will have to work with other parties in powers and state to look at if the states can step in to bring in marriage reforms or laws that can actually help LGBTIQ people enjoy the full rights of marriage equality.
Harish Iyer, do you have faith in the legislature, especially with the kind of conversation that has gone down? No political party would really want to put, or at least we've seen in the recent past, you know, put their weight behind your cause.
That's not absolutely true, though. There are some people who have put their weight around us. We have had Supriya Sule speak about it. We have had Jagdambika Pal from the BJP who has spoken. Now we have no other choice but to go to the legislatures to further our advocacy. The elections are coming, so it'll be a good time to tell them as well that you'll get our votes. We are 17% of the population. You'll get our votes only if you stand up with us.
You know, just 10 seconds if I can get Karuna back into this conversation. Karuna, away from, you know, the legislature, legally, what's the way forward now?
Well, we're going to have to look at the judgment's nitty-gritties. It only came out about half an hour ago. And look at what can be done in the interstices. Like, look, there are various queer rights aside from marriage that have been recognized by this set of judgments. That's a place that additional work can be done. And I wouldn't say that the legislatures should be, you know, binned en masse, right? They are, after all, democratic representatives of all our people. And the state legislatures are very important sites of these protections. And if these parties are going to say that they are a real alternative, then let them demonstrate that.
Okay.